Great. So welcome everyone to Sprintlaw's January edition of our monthly webinar. This month we'll be covering the new privacy laws that have come out in Australia late in 2024, really focusing on their impact on small businesses. I'm Alex, I'm the co-founder of Sprintlaw. Before we get into the content to today, just wanted to give you a quick introduction as to who Sprintlaw are. For those that are not already clients, we're an online law firm really designed to make legal services accessible for startups and small businesses. Everything we do is done on a fixed fee basis in terms of our legal services. We don't do hourly billing. We operate in all the different areas of law that your small business might need help with, anything from helping you set up a company, protecting your intellectual property, privacy protections, obviously, which we'll be talking about today, employment law, and more. We have an optional membership, but the majority of our clients sign up to it, and it's a really great, basically suite of software tools and service features that are really great for smaller businesses to generate some documents yourself, book in quick chats with lawyers whenever you need it. We've got a DocuSign type e-signature tool in there. We have AI features where you can get instant answers to legal questions. You can monitor your business's legal health. And there's a ton of additional features as well. So for anyone who's not a member, would consider checking that out. There's a free tier you can sign up for on our website to start getting some of those benefits. Bit more about us. We've been around for about 7, coming up to 8 years now. We're a fast-growing legal startup. We have a bit of 8,000 clients now, actually. Lots of happy customers, a team of over 50. We are based in Australia, but have expanded over to New Zealand and the UK as well, and won lots of industry awards. So we're pretty awesome, is what I'm trying to say. And for those who are gripped by the inexplicable urge to get some advice on privacy-related questions after this presentation, you can book a free consult with our team. We'll drop a link in the chat as well. And we're happy to chat through any issues that might be specific to your organization. So today we're going to be talking about the new privacy laws. There were some amendments made in November 2024 to the Privacy Act. Not all of the amendments we're expecting have actually been made, just kind of what we're referring to as the first tranche of changes, so that there may be more coming. But we'll talk a little bit through the history of what led to these changes and then exactly what's changing with a focus on how it might affect smaller businesses. We'll then be going through in general, what are your business's legal obligations in relation to privacy and what that means now, of course, with these new laws in place. And we'll also talk about some non-legal things that you might want to do to help protect your business, which again may assist in light of some of the new laws. Now, as I'm going through, do feel free to drop questions in the Zoom Q&A feature. I'll keep an eye on them, and I'll try and actually answer as we go through the slides, but I'll also leave a little bit of time at the end to kind of round up any questions. What are these new changes? Well, let's just start with the history of these changes. The trigger for the changes that happened last year was off the back of a review the government did in 2023 called the 2023 Privacy Act Review, which was really designed to address concerns that the Privacy Act 1988 was no longer suitable for the digital age in light of increasing data breaches, evolving global standards, and really fragmented privacy laws. People would be aware, of course, it was all over the news, the breaches that affected Medibank and Optus back in 2022. Customers' information was stolen by sort of malicious hackers. There's also, people may be aware, the GDPR regime was introduced in the UK and Europe back in, I think it was 2018, so many years ago now, with much stronger sort of privacy regulations and standards. There's been a movement around the world. In California, there's a CCPA as well, which models a lot of its regimes off the back of the GDPR. And a lot of this stuff is really designed to improve privacy protection for individuals who are working, in particular with businesses or other types of organizations. And the Australian system has had some updates, some changes over the last few decades since it came out in 1988, but really these quite significant new standards that have been emerging across the world have not been reflected in Australia's privacy laws. There's been a lot of talk that we really need to catch up, in part because when we do international business, the Australian suppliers often struggle when they're working with international suppliers to do deals when we're not seen as a nation to have up-to-date privacy laws. It makes some of those deals more difficult. So Lots of impetus for making these changes. The review was an in-depth review, and there was 116 recommendations for changes to the privacy laws. The government, in its response to the review, accepted 38 of the proposals. It said it was going to do them, and 23 of those 38 are included in this November change. Now, there's 68 others of those 116 which the government sort of agreed in principle, agreed with the concept, but stated it needed to, consider further and undertaking further consultation before it committed to actually passing that into law. And then the remaining 10 were kind of not noted for no immediate action. So a lot of this 116 is likely to end up in the law at some point. And really, when we're talking about this tranche one, which was in the name of the bill, it's kind of the first stage of a series of changes with what I guess the government wanted to get through sort of first. So there will be likely future webinars that we run as these more of these proposals are accepted into law, to inform you as to what changes there are that may impact your organization. But for now, we're obviously just talking about the 23 that came into effect in November. So I've summarized on the next couple of slides what some of these changes are, and I have some examples of how it may potentially impact a smaller organization. So the first is this introduction of a tort for serious invasions of privacy. And so this is a new statutory cause of action which allows individuals to sue for serious invasions of privacy without being limited to the scope of the Privacy Act. And so previously, if you as an individual had an issue with an invasion of your privacy, you could complain to the regulator and sort of hope for action. But if you actually wanted to sue someone directly or hold someone accountable for legal liability, it was possible, but not really possible directly to do so under a privacy action. You might have to construct some other kind of action. So it was complicated and not super clear whether individuals actually had the right to sue for an invasion of privacy, and this is now explicitly been established as a new cause of action. And so some examples of this, how this may play out in practice, you can imagine a marketing company might share or sell customer information without an individual's consent. And this could breach privacy laws if it was considered a serious invasion in terms of the data that was sold. If a company neglects to update known vulnerabilities in its systems and there's a data breach and that exposes sensitive customer information, the company could be liable. Now, previously, what may happen in these kinds of circumstances is the regulator may investigate and issue a fine or penalty, but now actually the individuals affected themselves can also sort of go after the company directly. And so that's quite a significant change. If you've got millions of customers, there's now potentially millions of people that you could be liable to directly with this tort for serious invasions of privacy. So the stakes are now higher on protecting customers' personal information with this tort. Invasive surveillance, a small business installs software on employees' work computers to monitor their keystrokes, screen activity, and personal emails without informing them, and can see their personal communications. So this is something that, particularly in the digital age, organizations are installing systems to see what their employees are doing. If they misuse that software, again, you can imagine serious invasions of privacy occurring and then direct liability to those individuals affected. So a few scenarios there. And again, some of this stuff under the previous privacy laws may have been in breach of the laws, but individuals did not have a clear right to hold the organization accountable. And it was more about the regulator, which really a lot of the talk in the leading up to the 2023 privacy review was that, OAIC, the privacy regulator in Australia, didn't really have that much funding or enforcement ability. And so, there was seen to be lots of breaches of the Privacy Act happening with no real consequence. And certainly those of you who may have been running organizations for years have maybe thought, oh yeah, I've heard about these privacy laws, but doesn't seem to be something that I ever hear anyone getting in trouble for. a big part of the regime change is, okay, we have these laws, let's strengthen them and actually start enforcing them. So the future may not resemble the past in terms of privacy compliance, and it's a great time to sort of get on top of it if you're not already. So anyway, that's that tort for serious invasions of privacy. We've got doxing criminalisation. So there's a new criminal offence inserted into the federal criminal code for doxing, which is the malicious release of personal data online with penalties of up to 6 years imprisonment. Again, applying that to an organizational context, you can imagine a small business owner posts a LinkedIn update naming a disgruntled customer who left a negative review, including the customer's details. And I've seen this on social media before, small business owners complaining about a customer and they post a review online or an email online, not realizing that they've included all of the personal information of that customer. And they may be intending to, they think, just defend their reputation. But if there's harassment suffered by the customer as a result, the business owner could actually face criminal charges. So it's quite a serious penalty now for this kind of stuff. And again, you read about doxing and you think, oh, that won't apply to me. I'm not going to be leaking people's personal information. But when you see examples like this, you can see how it can happen through sort of reckless conduct. And again, the penalties for this stuff is serious. So very much worth kind of being aware. Moving through some other of the changes, we have automated decision making. One of the changes mandates that organizations disclose in their privacy policies the types of information used and decisions made through automated processes that could significantly affect individuals' rights or interests. This is in part in response to concerns around algorithmic AI-related decision making and how that may affect the disclosure of people's personal information. Again, to give an example, we got a small online lending company. They're using some kind of algorithm to assess loan applications and determine approval or rejection. And the system's analyzing their personal information, looking at their credit scores, their income, their spending patterns, their demographic details, putting that all into an algorithm and then automatically spitting out whether they're going to approve or reject the loan. Something like that, if you're going to be doing things like that, using algorithms to automate the decisions, you really need to disclose in your privacy policy what are the ingredients that are being used, what kind of personal information is being used, in your system to make these kinds of automated decisions. Something certainly larger companies do a lot more than smaller companies. And I think this is likely to affect larger companies more than small organizations. But again, we have an example of smaller organizations that may do this sort of stuff. The law also requires the development of a children's online privacy code. Now, the code hasn't actually been released, and it's expected to come out actually in quite a while, in September 2026. But it's designed to better protect minors' privacy online. And again, difficult to know exactly what will be in there, but in general, if you're in a space that deals with children, it's worth being aware that this code's coming. And you can imagine, a small ed tech startup has an online learning system for primary school students. The system's collecting names, ages, behavioral information to customize the educational content. And again, there's a lot of new ed tech startups coming out doing stuff like this. And again, if it's using a child's personal information, their name, their age, and data about their behavior, it's going to need to comply with the code. And again, it may affect the way that organization actually builds their technology. And finally, we have enforcement and penalties. So this is what I alluded to earlier. It's all well and good to make a lot of these changes and to strengthen the privacy laws, but for many years, an issue for the OAIC has been that they just didn't have enough funding or powers to enforce the law, and many organizations have sort of just been ignoring the privacy laws and thinking that they won't get in trouble for it. And so the OAIC has expanded powers beyond, in 2022, there were some reforms which we covered in the webinar then as well, but the powers are even stronger now. and now they can issue compliance notices requiring businesses to address risks before breaches occur. So it doesn't just need to be in response to an actual issue. If there's poor practice, they can actually issue sort of these statutory notices. There's still this tiered penalty regime, which was introduced in 2022. The fines can be up to 50 million. Now, maybe unlikely for a small organization that doesn't have revenues of those amounts to be issued the maximum penalty, but it's not necessarily, although one of the ways that the penalty is calculated can be related to the revenue of the organization, it's not necessarily tied to the size of your organization. So you could be a small organization that suffers a business-ending penalty. So the stakes are high. And again, an example we have here is a small e-com business has a data breach, names, addresses, payment details are exposed because they didn't have up-to-date security systems. The OAIC could proactively investigate the business and issue a notice to upgrade their systems. And if they fail to comply with that upgrade, they could get fined a significant amount of money. And again, smaller fines could be significant and could really be business ending for smaller organizations. So definitely worth being aware of these changes. So those are the key changes really that I think affect smaller organizations that came out in this first tranche. Now, there's further changes expected. As I mentioned, 38 were accepted by the government, 23 have been put into place. So, there's another 15 there that we expect to come through. And these are some of the ones that we're expecting later this year, early next year. Anything's possible. It may be that, these don't happen or it takes longer for them to come through. But my view is it's pretty likely we'll see this stuff come into force. And I think it's worth being aware of what's coming now as well, because you just want to make sure in your current practices and the way you're setting up your organization, you're going to be ready. You're starting to think about privacy more. It takes time to make changes to the way your organization operates. And you already have seen the direction things are moving with these first tranche changes. These second tranche changes, I think, particularly for smaller businesses, could even be more significant. And so if you're kind of compliant already and undertaking best practice, it'll reduce the impact of these future changes. So up the top, we have probably the most significant change affecting smaller businesses, which is the removal of the small business exemption. Now, Australia has this exemption, not a blanket exemption, but a fairly broad exemption to compliance with the Privacy Act for small businesses with turnover of under 3 million Australian dollars. They're currently exempt from the Privacy Act. This means that Privacy Act compliance is optional, and it means that many of the laws around, having a privacy policy and seeking upfront consent for information, you don't have to comply with them. You can optionally comply with them, but you don't have to comply with them, and you wouldn't be in breach of the laws. And this is a reason why many small businesses haven't taken privacy seriously. Now, there are exemptions under the current regime for businesses that collect health information or trade in personal information or collect other forms of sensitive information. So it doesn't matter how big you are for those types of information, you have to comply. But for many small businesses that aren't doing anything special with personal information, there is this exemption they can rely on to say, oh, well, look, I wasn't required to comply with the Privacy Act. There is, a real chance, I think it's likely to happen that this is going to be removed potentially this year. And if that happens, it is a fairly big compliance burden now small businesses will have to comply with all of the different Privacy Act laws. At minimum, that's going to mean you will definitely need a privacy policy. You're going to need to have privacy collection notices. You're going to need to make sure that your processes and procedures consider personal information. You've got data breach response plans, et cetera. So there will be additional steps small businesses need to take. And again, to the extent you can do some of that for now, and I'll cover for the remainder of this presentation some of the key steps everyone should be taking to make the impact of these changes not as significant. But to the extent you can do that now, I think it's a really good idea. And just to clarify, some of the changes I covered, for example, the tort for serious invasions of privacy and doxing criminalisation, even as of now with the November changes, they're not limited or part of the Privacy Act. So there's no small business exemption for these changes. So you have to comply with these or be aware of these today. But some of the changes here, the OAIC penalties are about the Privacy Act. So for the businesses under 3 million in turnover, some of those things don't currently apply. But as I said, I think it's a good idea to act as if they do apply or everything applies, because I do expect this exemption to be removed. Jen's asked, will the small business exemption removal extend to charities? I think it will. There hasn't been really clear discussion of around accepting charities. And even today, for charities that are under 3 mil in turnover but are collecting sensitive information, the Privacy Act would apply. So yes, it is very possible that that these changes are going to affect charity organizations as well. Introduction of a right to erasure is also expected. This kind of aligns with what we see in the GDPR. There is currently limited rights for individuals to request the deletion of personal information. Now, they have the right to ask for some information about what you're doing with their personal data, which again, I'll cover later in this presentation. But what's proposed is basically the right to be forgotten or the right to erase. So an individual can at any time send an email or request to an organization and say, delete everything that you know about me. Now, that is easier said than done, because if you think about in your organization, someone contacts you, if you particularly run cloud-based or digital systems, you'll probably have their name and email in 10 different places. It'll be in email inboxes, it'll be in spreadsheets, it'll be in order systems, it might be on your website. How do you actually go about complying with the request to delete everything you know about them? For smaller organizations, this can be difficult. And so again, I would encourage people to start thinking about, okay, where is all the personal information in my organization stored about my customers? Do I know where it is? Do I have a register or record of where it all is? And if someone asked me to clear it, could I actually do that easily, or would it be complicated? And I think building these systems is going to be kind of important part of compliance. Currently, employee records are exempt from the Privacy Act. So employee information is not necessarily treated with the same level of care as customer information or other sorts of information. So that's going to be changed likely. In Australia, the Privacy Act also lacks clarity on this distinction between what in Europe they call data controllers and data processors. And this kind of is a concept of, if you think about in your organization, you will collect people's personal information from your customers or whatever, and then you'll store it in software systems. And so really, when someone gives you their personal information, not only are they giving it to you, they're also giving it to all of the software companies that you work with. And that's that means that they want to be aware of that, and B, they're kind of trusting you that you've picked good software vendors to store their personal information. And so this is this distinction they have in Europe. The person collecting it is called a data controller, and the software company that kind of helps them store it is called a data processor. And there's a lot of obligations on the controllers to do their due diligence on the processes and make sure that the way that they're storing and holding the information is compliant and consistent with the law. So I think as this change is introduced, what it's going to mean is you're going to have to take a look at the software companies that you use, the softwares that you use, and get a bit more information from them on whether your customers' information will be safe with them. So a couple of questions have come through. David's asked, "Hi, what if the statute of limitation where a client has 6 years to sue me, but within that time I have to delete all reference to them." So look, there are some laws around limited periods for which individuals or people with a legal claim can sort of commence proceedings, and depending on the type of proceeding, that period can vary depending on the agreement that it relates to. That period can vary depending on the state that you're in. It can vary. I think to answer that question, it would kind of depend on what they're suing you for. But I think it's probably not worth considering compliance through the lens of, well, they only have a specific time period and they don't have to go back all the way into history. I mean, some of these potential penalties that may be issued are issued by the regulator, which may not be subject to any statute of limitations. Again, the period at which the breach occurred, could be at any time and affect any kind of customers. So yeah, a bit difficult to answer that question in the abstract. I don't think it's super relevant to considering your compliance. And again, there's often, as you can see, many different ways you can be liable. It can be a fine from the government or a cause of action from an individual. So the statute of limitations, may or may not apply. Marie's asked if information is deleted for an individual, are there exemptions? For example, if there were allegations, investigations of child sexual assault, as many of these claims are historical. That's an interesting question. There are conflicts, for example, in this right to erasure with obligations, for example, that we as lawyers have to retain client records for a period of time. So there will be a balancing act undertaken, and I mean, this law has not been released yet, so I can't really answer the question until this right to erasure kind of comes out. There's likely to be a balancing act or exemptions to the right for criminal proceedings that are underway, or for professions like lawyers that are required to retain certain types of records. I think there will be exceptions to that. So yeah, I don't think it will be a totally blanket right to erasure. And if you look at the regime over in the UK and Europe, there have been exemptions to it. But I think for most practical purposes, and without those exemptions, the points I made earlier about probably needing to, in most cases, erase the information that you hold about a person, that's going to apply to most businesses, even though there will probably be some exemptions. Coming back to this list of expected changes, we're expecting more enhancement of individual rights. The current rights are pretty limited in scope for individuals. We've got this new tort for serious invasion of privacy, but what about the right to not only have your stuff erased? What if you want an export of the information that someone holds about you? What if you want information about what they've been doing with your personal information? It's possible, and in fact, in some of the 38, probable even, that we're going to see even more rights for individuals to not only ask you to remove their information, but actually ask you for access to their information. And again, there are some rights at the moment, but it's proposed to make these even stronger. Again, like if you're using software systems now that make it difficult for you to kind of actually have a historical record of what you're doing with people's information, and make it difficult for you to export information or give access to people's information, you just want to be thinking early on, when I'm trying out a new software, or in the software that I'm currently using, how good is their privacy protections, and how easy is it to delete stuff or export stuff? I mean, those are steps I would be suggesting people take right now, because you don't want to be in a situation where you just signed up to a new software system, you've set it all up, and then 6 months later, the privacy law changes and you wish you never set up with that vendor, if that makes sense. I would be thinking about it now. So yes, those enhancement of individual rights could have a real practical impact on what you do. And finally, we've got mandatory privacy impact assessments. And so currently, these privacy impact assessments are recommended but not compulsory. And so what is a privacy impact assessment? Well, similar to what I've been alluding to earlier, it's this process that organizations should undertake really to look at their organization and go, okay, well, where are people's personal information? What systems are they stored in? And where are the vulnerabilities and risks? It's a great idea for everyone to do that, because if you're doing that, you're limiting your liability here. You're probably running a tighter organization, and certainly reducing the risk of fines for non-compliance. But it's an optional activity. It's a good idea, but it's not required. And it's proposed that organizations, and so potentially only those that conduct high-risk activities, would be actually required to undertake these impact assessments. So that's another compliance step. A couple of questions in the Q&A. Willie's asked, can I include in my contract that data deletion is not applicable if seeking legal actions, particularly if that information is needed for legal purposes during legal actions? Yeah, an interesting question. Again, I think right now, it's difficult for me to provide advice on your specific situation without knowing what your organization does. But in many cases right now, it would be possible to write something like that into a contract. It would just depend on what kind of information you're collecting, what you mean by not applicable, and if a legal action is commenced or it's it might happen one day in the future. I mean, a broad version of that clause could be used as a justification for not deleting anything, because one day there might be a legal action, if that makes sense. So I think, but it would be broadly possible on the current law to draft something like that in certain situations for ongoing legal proceedings. Whether or not that will hold up in the same way or be affected by the introduction of a right to erasure, I can't say, because we haven't seen what the government's going to actually do with that right. So again, I think you're just going to, in general, for an organization, you're going to be wanting to prepare for the ability to delete information. And as I said earlier, I do think there will be some exemptions for ongoing legal proceedings or certain professions, but I don't think organizations could rely on just wording in a contract to kind of supersede this, what will probably be a pretty strong right. Nick's asked, one big struggle with the right to erasure correction export is identifying that the individual requesting is the one who has the right to do that. When someone asks to erase their data, we request proof, but then aren't we supposed to keep a record of the documents they give us to prove they are who they are? And how is this going to be resolved? That's a great point, like a really, really, really good question. And look, I think the way that's managed, I think, under the GDPR is, which by the way, this regime, the right to be forgotten, currently exists, is a balancing act. So you have to take reasonable steps to make sure the person who's requested the right to erasure is who they say they are. But of course, you may at that time say to them, I require this information from you to verify you are who you say you are. And do you consent to me holding and retaining this to do so? And they may then say one of two things. They may say, okay, I'm okay with you holding on to my proof of identification information, but only for 2 weeks while you check who I am. Then I want you to delete that too. And then again, you've got consent to hold it for a period, but then you have to erase that afterwards. Or they may say, I think you don't need that much information that you've asked. It's me because I'm logged into the account, and they could make a case that you're asking for too much, and that might be resolved on a case-by-case basis. So, it is a nuanced situation, but I've, I guess, described a couple of ways that we see over in the UK and Europe that it's managed. And I expect that will kind of be how it plays out in practice in terms of, the KYC, know your customer process, and matching that with then needing to delete it. You hold it temporarily, and then you have to clear it, or they only provide you more limited information as required to verify they are who they say they are. Anthony's asked, is it fair to characterize the changes as equivalent to the GDPR overall, or do you think there'll be significant differences specific to Oz? A good question. I think it is certainly modeled on the GDPR. The right to erasure is definitely inspired by the right to be forgotten under the GDPR. These access request rights are as well. The controller process, the distinction is. So much of it is modeled, but I do think there will be significant differences. I mean, the GDPR itself, I said back in 2018, it came out. We have the benefit now of seeing all the flaws in the GDPR, of which there are many, and there's pretty significant issues with some of the compliance measures, around cookie policies and so on. So certainly the 2023 review suggested things that are not in the GDPR. Some of this stuff around doxing and tort for serious invasions of privacy are Australia specific and are kind of relevant to you know, we have a different system, certainly to European countries and even to the UK in terms of our constitution and individual protection rights and rights to privacy and all that sort of stuff. So some of these changes are Australia specific in the way that they work. And I think also, you know, with large language models and AI being released in a big way since 2022, the GDPR is not that up to date with that stuff, and there's proposals related to that. So I think crudely, if you took steps to be GDPR compliant today, you would be in a very good position to be largely compliant with the new changes. But there's still going to be a few more things that you need to think about. So yeah, hopefully that answers that one. We have a question, what's classified as high-risk data processing activities? Can you please provide examples of these activities, please? Look, I think it's things involving sensitive health information, things involving passports or critical documentation, things where if the personal information was leaked, it presents a high risk to the individual of identity theft or fraud. I mean, a password to someone's bank account or whatever it is, things like that, could be considered pretty high risk. So I think it'll be a qualitative test. And again, the law around what is high risk is not out yet, if you will, but we have the concept of sensitive information under the Privacy Act, and it refers to the sort of stuff that I mentioned. So it will be similar. And again, if you look at some of the examples given in legislation around significantly affect individuals' rights or interests, it's really talking about that kind of stuff. So that gives you a flavor. And of course, if you have a specific question, I would always suggest running it by a lawyer to work out whether what you're doing is high risk or not. But that's the sort of stuff that we're talking about. And Pamela's asked, would this impact the accounting industry on the time limit imposed on destroying past clients' information, or will that remain as currently determined by the ATO? Yeah, look, I think that's similar to the legal profession's requirement for holding on to historical client information. Unclear exactly how that's going to work under the right to erasure, but my expectation is these profession-specific requirements to retain certain records will be exempted from these rights to erasure. That's certainly how it works over in Europe and how it's been discussed in Australia. So I can't say for sure, but my suspicion is it will be exempted, as you've kind of stated in your question. Okay, so let's now talk about what steps you should be taking now, today, and potentially in the future to make sure that your organization is safe from potential liability, or as safe as it possibly can be from potential liability or fines related to these changes. I think organizations should think about what they need to do in these three buckets. First of all, make sure that your organization is generally compliant with privacy laws, and I'll talk a bit more about what that means. So in peacetime, if you will, maybe nothing's going wrong, but just set up your system and your organization to care a little more about privacy with processes, documents, and procedures. That's the first thing you should be thinking about doing as a kind of to-do action. The second is be aware if there's an incident. So we know in wartime something goes wrong, someone breaches your systems, your personal information's leaked. Hopefully that doesn't happen to you, but if it does happen, if you're subject to a cyber attack of some sort, be aware of what you need to do and who you need to tell and how you need to think about it and what processes you need to follow. And finally, and this is more of an indirect point, but be aware for those of you that are directors of organizations that this stuff is increasingly pretty high stakes, and directors have duties under the Corporations Act to sort of exercise their position with due care and skill and a number of other responsibilities. As directors, when you set up a company to run your organization, one of the reasons we do that is to benefit from limited liability, where things that go wrong in the business don't affect us personally. They have no impact on your personal assets if there's liabilities in the business, but there are exceptions to that, and especially for directors where you breach those duties. And there has been talk, I don't expect it to come through in the Tranche 1 or 2 changes, of more explicit obligations on directors of companies to be held sort of personally liable for issues with non-compliance of their organization with privacy, which of course would make it super high stakes for people to really be complying with this stuff. But even without that explicit sort of director's duty around organizational privacy, still, there are potential individual liabilities, and we talked a little bit about the criminalization of doxing. So, that could have individual criminal penalties for organizations that are encouraging or undertaking that behavior, and also, I think claims could be made if you really aren't investing in any sort of cybersecurity and leaking people's information left, right, and center, and really doing a poor job of this stuff. I think claims could be made that you can't hide behind the organization, and you as an individual may be liable. So I would really take this stuff seriously, because I do think, particularly in the current climate and the move towards stronger privacy compliance in general, the stakes are getting higher, and as someone running an organization, we're certainly taking privacy very, very seriously and investing more and more into this stuff. So anyway, I just wanted to kind of make that point. But let's talk about practical steps in terms of general privacy compliance. First of all, what you can do. We've got our Privacy Act. We've been talking about this the whole time. This is the main piece of law. It's the piece of law that's just been changed, and it's the main thing you want to comply with when we're talking about handling personal information. And so this is the Act covers, like, anytime you're collecting people's personal information, using it, storing it, sharing it with people. This is the space that the Privacy Act plays in. And so, of course, the question is, does it apply to your small business? And this is the current law. Do you handle personal information? For the vast majority of businesses, the answer is yes. Personal information, which is a core concept in privacy law, is information about an individual that could be reasonably used to identify them. So, do you have their name? Do you have their phone number? Do you have their address? Anything else about them that, if someone read that information, they could work out who it is. That is personal information. And again, most people will have that if they're fulfilling orders or servicing a customer. They're going to be holding personal information. So usually a tick for the first one. Number 2, this is the small business exemption. Do you have annual turnover of over 3 million? If the answer to that is no, then we look at the second part of the sentence. Are you a health service provider, like collecting health information, or do you sell and trade personal information? And if the answer to that is also no, the Privacy Act as of today does not apply to you. But as I said earlier, as of maybe by the end of this year or next year, we might be deleting that question. So still pay attention, even if the answer to that is no. And thirdly, do you have special categories of personal information, sensitive information, TFN, government-related IDs? Accountants obviously often have these sorts of things, credit card numbers that are non-tokenized, so you actually have the full credit card number. That stuff is governed by the Privacy Act. And by the way, I should say, even if you're under 3 mil, you're back in if you tick that box. And then another question is, do you conduct any kind of act or practices that's exempt from the Privacy Act? And that's quite industry specific. So I won't go into that in detail. But these are the kind of core criteria for whether it applies to your business. And the answer for most businesses above 3 mil is yes. And for those under 3 mil is no today, but might be yes tomorrow. And even if it's no today, if you ever hope to be above 3 mil, it will apply to you. And also, as I said, it's a good idea to be compliant with what I'm saying anyway, given the likely changes. So what do you actually need to do? 1, get your documents in place. 2, prepare for these breaches. 3, be prepared to respond for questions from customers about access requests. And 4, do some non-legal documentation stuff, which I'll talk about a little bit at the end in terms of cybersecurity and insurances and those sorts of things. So these are kind of the key steps you want to be taking. In terms of the documents that you need now, somewhat unhelpfully, the Privacy Act, it doesn't give you a to-do list of documents that you need. It does talk about a couple of documents, but it takes what it calls a principles-based approach, and it has these 13 principles, which basically say organizations who've got personal information got to basically handle it in accordance with these principles. They have to be open and transparent with people about what they're doing with it. They've got to keep anonymity where they can. They've got to be clear about handling information that they've requested and versus stuff that the customer's given to them, solicited or unsolicited. They've got to notify people at the time they're collecting it, tell people how they're using it. There's stronger principles around direct marketing if you're doing like door knocking and that kind of stuff, and so on, security and access and correction. So there's a ton of different principles, and so this is nice but not super helpful for an organization to know exactly what they need to do. And hopefully, lawyers and legal cases over time have helped establish the key types of documents you need to really be ticking the box for complying with these principles. And so we have on this slide the key documents that organizations should be putting in place. And so, privacy policy is number one. It's actually mandatory because the Act specifies, or the principle itself specifies, that you need to have a privacy policy. So if you're covered by the Privacy Act, you don't have a privacy policy, you got to get one. You also need a collection notice. You can't just have a privacy policy hiding off on your website, not linked anywhere, and expect people to just go find it. Anytime you're collecting people's personal information, whether it's on a web form or on paper or whatever it is, you've got to tell them about the privacy policy and tell them why you're collecting that specific information and what you're going to use it for. So it's not enough to just have the policy at the time of collection. You've got to notify them of it and tell them what you're using it for as well. And oftentimes you see on forums people say, we'll collect this to contact you, and we'll handle it in accordance with our hyperlink privacy policy. So that's what a collection notice is. It's just that kind of shorter sentence, but it can be longer if you're collecting different kinds of information. So those are the two that at minimum you want to have. The other things that you may want to have, and I think the may would become a strong may if as these laws change, is one, undertaking an impact assessment of your organization. Where is all the personal information held? What security measures do we have in place? Am I confident that the vendors that I'm using are going to treat it carefully? And do I know what to do if I need to clear it or export it? Two, if you engage in direct marketing, and I'm not sure how many attendees here do, but if you are holding information for direct marketing, there's a policy that you should have in place for handling that to make sure you're complying with the direct marketing APP. If you're sending information overseas to organizations that are not covered by Australian privacy laws, so that's any vendor, supplier, contractor offshore, even software organizations that you use that might have servers offshore, you need to make sure that, or you should make sure rather, that they are complying with the Australian privacy laws, because customers giving it to you, you've given it to them. You can't just say, oh, it was their fault, not ours. If the customer suffers an issue, they're going to hold you responsible, as they may be able to do under law. Thirdly, data breach response plan, security policies, these sorts of things for when something goes wrong. What are you going to do to limit the damage? Not required, but a really great thing to have to be prepared for those scenarios where there is a data breach. And finally, these access requests, if someone asks for access to information. As I said, there are some rights right now. They're likely to get a lot stronger. Do you have a process for complying with those requests? So the top two, if you don't have them, I would strongly suggest you get them. And these other ones are really good to get in place. And obviously, if you need lawyers to prepare them for you or help you with them, it can cost money. So it may be something you tick off slowly over time. But certainly, I would suggest really investing in this stuff to make sure that you are really complying with the laws and where the laws are going. But at minimum, for those that don't have these two up-to-date ones, I would suggest that you get them. So those are the key documents needed for the Privacy Act. Now, I mentioned before, one of the reasons we're having these reforms is because the privacy laws are a little fragmented. And it's not just the Privacy Act that deals with privacy in Australia. So there's a ton of other laws. These don't have small business exemptions. And they're worth being aware of. We don't have time to go into all of them in detail, but if you're in a particular industry, childcare, for example, there's the state-based laws in New South Wales. We have the Child and Young Persons Act that has laws about handling children's information. You've got to comply with that. For those that do email marketing, which is most people these days, they send out newsletters and reminders. We've got the Spam Act. The Spam Act requires you, and again, no small business exemption, to get permission to email people before you bother them, and also to have an unsubscribe feature. So again, we got to do that. Most people are aware of that, but important to know if you're doing email marketing. If you do this direct marketing via outbound phone calls, you can't call people on the do not call register list. If you're watching employees, surveilling them, recording their conversations, we've got the Workplace Surveillance Act. And also, if you're recording phone conversations with customers, there's a Surveillance Devices Act, and you've got to provide people with notice of that sort of stuff as well. So there's other laws that apply. And again, anytime you're doing these activities that involve tracking what people are doing and collecting that personal information, you just want to ask the question as to what laws might apply. For those that are Sprintlaw members, we have part of our membership these unlimited quick calls. So if you're not sure or suspicious, do just pick up the phone and ask us, and we can give you quick answers to these questions as to whether there's something you need to do or not. So now moving into the wartime, what if something happens and someone hacks your small business and steals all of your customers' information? What do you have to do? Well, under the Privacy Act, we have something called the Notifiable Data Breach Scheme. Now, again, currently exempted for under 3 million turnover small businesses, likely to change soon. And when a breach happens, there are legal obligations if this act applies. It's not just enough to try and stop it and then apologize to some people and handle it using common sense. You actually have a requirement to consider. First of all, first step is what steps you're going to take to contain it. You must do everything that you reasonably can to reduce the breach continuing, getting IT experts involved as quickly as possible, and shutting down access, changing passwords, whatever it is that you may need to do based on the particular type of breach. 2, you need to assess the damage. What has been leaked? What do they get access to? And the big question under these laws is, has an individual been put at a substantial risk of harm as a result of this breach? Now, if someone's accidentally forwarded an email they shouldn't have with not much sensitive information of one customer to a known supplier, for example, that's technically a data breach. Someone's personal information, their email address has been leaked, but it may be not likely to cause any significant harm to the individual whose email address was leaked. Versus if on the other extreme, and ransomware attackers have taken your whole customer base's information, threatening to leak it on the dark web and impersonate them and hack into their bank accounts. That's very likely to have a substantial risk of harm, and every breach will be somewhere on the spectrum of unlikely to be substantial risk of harm to very likely. Now, if it's unlikely, you actually don't have to notify the person affected. It doesn't require you to tell them every single time something happens. It's only if it's more up the other end of the spectrum that you need to, but you need to undertake the act of assessing the damage. If they're at substantial risk of harm, you have to notify them. You have to also notify the regulator, the OAIC, and then you have to review your systems and processes. Again, having a plan for this and a procedure internally, if something goes wrong, what are the steps we're going to take, is a really great way to make sure you tick these boxes. If anyone here is unlucky enough to suffer a breach, just know that you want to get in touch with your lawyers as quickly as possible. People should also consider taking out cyber insurance. Your insurers can really help in these situations as well. Now, if you take all the steps that are listed here, you may or may not still be fined or suffer liability from the users or the OAIC, but it's going to significantly reduce your liability. I mean, if a malicious third-party actor has come in and hacked your systems and you did your best to protect yourself with all the best security standards and you followed all these steps after the breach happened, it will be difficult for someone to argue that you're liable for negligence or breach of privacy laws, and so you may not suffer liability if you are best practice. But if there are holes in your approach, you were lax, you didn't have the latest systems in place, and you don't follow these steps and don't limit the damage, this is where real liability can come in. So that's why it's important to be ready for wartime. And like I said, if nothing else, don't just sit on it. If something happens and you don't feel like you're ready, you definitely want to get in touch with legal advisors and potentially insurers. We're low on time. I will go a little bit over for those that want to stay and answer some of the questions that I see in the chat, but there's just 1 or 2 slides left. I'll quickly run through and then pull the questions, but do feel free to stick around because I will go for maybe another 7 minutes or so. So just the final thing I wanted to cover is under the existing Privacy Act, and this is likely to be strengthened under the future laws, there is the right for an individual to submit what's called an access request, to request information or make a complaint about the way that an organization is handling their personal information. So the Privacy Act sets out that basically if there's a complaint, the individuals actually have to contact the organization first before complaining to the OAIC, the regulator. And the business needs to have a process for that. So, typically in your privacy policy, you put a contact person and email address there, and then you've got to be ready to handle these kind of complaints or requests. And so it's important to have that process set up. It's a compliance action, and if you have that in place, then the OAIC will refer people before they try and make a complaint about you to talk to you first directly and try and resolve it. So important to set up that process. Now, individuals might contact you and say, even now, even though they don't have an explicit right, they might say, hey, I want you to delete everything that you hold about me, or I want you to tell me what you're doing with my information. Right now, you can refuse those requests if you've got a reasonable reason to do so. It's expensive, it's costly, it's complex, it's not possible. But if you can comply, you're meant to comply under the laws, and you have to be reasonable in your refusals. As I said, it's possible that the ability for you to refuse these requests is going to be significantly reduced with some of the new changes that are coming. So at minimum, if you don't already have an email address and a privacy policy set up to handle privacy complaints, I would suggest doing so. For Sprintlaw, if you check out our privacy policy on our website, we have, I think, a privacy@sprintlaw.com.au email address, and people can email that if they have questions for us, and we get back to them with answers to those questions. So something like that is all we're really talking about here, and having a procedure to respond to them is important. Finally, just looking beyond the law, here are some other things that are best practice for privacy compliance. Consider taking out cyber insurance. Really great idea for the data breaches, and even the process of taking out insurance. The insurers often get you to go through a lot of the steps that I've covered here in terms of making sure your security is up to date, making sure you've got a process if something goes wrong, helping you limit the damage, and they can refer you to experts, IT people, if there's in the event of an incident. So I would suggest pretty much everyone consider cyber insurance if you can afford it. It's a really good way to at least have some protection. Consider getting experts in to look at your systems to make sure that things are robust. If there's IT professionals you can use to do that, we certainly have for our platform, IT experts check our systems, make sure that they're secure, and help us make them more robust. Consider those registers or impact assessments. Where is all the personal information held in my business? Do I know? Am I aware? And if someone asked me to delete it all, could I? Train your staff. A lot of the data breaches that happen are basically due to human error, some kind of phishing email or something tricks an individual employee who leaks access to the organization, and that's kind of where it happens. And so, you want to get your systems up to date. You want your 2FA or whatever you can, but to the extent that you can actually train your staff as well, it can make a really big difference. And then, put in your policy and processes internally. And if you're doing that stuff, you're getting your documentation in place, you're preparing for the breaches, and you have done some of the stuff I have on this slide, I think you're going to be in a pretty good place to be compliant with current and future laws. So hopefully people take that as a kind of takeaway in terms of the things that you may need to do. So I'll just quickly dive into the Q&As. That's kind of the end of the content. And I'll leave this on screen for those that have questions about what we discussed today. You can get a free consult with our team, and we're happy to discuss further. So just to round off these questions, Mark's asked, if you hold cyber insurance, should the insurer provide steps to take to be compliant?
So the cyber insurers, first of all, they are mainly concerned with the data breaches, and they are aware of the notifiable data breaches scheme, and they want to limit the possibility that they're going to have to pay out. So in practice, many insurers are pretty good at giving you steps to take to be compliant. Ultimately, just doing what they say is not going to be a defense, if you will. You're the one that's responsible. But you will find them helpful, at least for the data breach side of things, but only for the data breach side of things. For general compliance notices you provide to customers up front, these rights to be forgotten that we talked about, the doxing, all of those kinds of things, those processes and procedures are separate to cyber attacks. Privacy is not just about cyber attacks. That's one element. It's also about using information in a way that you have approval for. So that goes beyond the cyber insurance. And so very helpful, and I would suggest that people do that, and that will get you some of the way there. And then also working with lawyers is the other half of like, what other documentation do I need beyond like data breach stuff? And if you do those two things, I think that's a good way of getting through. David's asked, do companies have any such protection rights, or are they just fair game? Interesting. Companies, privacy law is concerned with personal information, so it's got the word person in it, and it's largely about people, their name, their address, their email, those kinds of things, and what you're doing with information about them. Companies, while they're considered a legal person under law, don't have those elements in terms of first name, last name, and demographic and whatever it is. But of course, they do have information. But yeah, the laws are not really designed for companies to protect information about themselves. And in fact, companies are required in many ways to be public about a lot of things. I mean, private companies can retain some information as private, but at least their name has to be publicly available and so on, and some address details. So they're not really in the same sense as personal is protected. I wouldn't say they're just fair game. If people are, defaming your company, it's kind of similar to doxing, for example. Someone writes false reviews or whatever. There are claims you can make to protect your company's reputation, and confidentiality can protect your company's information, and intellectual property laws can protect your IP. So there are protections for companies, but not really through the same lens or framing as personal information. As someone's asked, is working with children's count as government? With children numbers count as government-related identifiers. I'm not 100% sure what you mean, but government-related identifiers are more like tax file numbers, and those and passport numbers. That's kind of what we're talking about. But as I mentioned, there are. Sorry, you mean the WWC working with children numbers? That's a good question. I'm actually not sure. You might have to ask one of our lawyers to have a look into that as to whether the working with children number that people that do working with children checks get is a government-related identifier. I'm not sure of the answer to that question. Steve's asked, in the case of videoing a child and having consent to be recorded by a guardian, and the child becomes an adult and wants to have them removed from the videos, will that mean we have to fuzz out the person from the videos they are recorded in, can't delete all videos as that is in the business? That sounds like a pretty specific question to your business, and it is a good question. I'm not sure of the answer to that one either. I think that might require a chat again to one of our lawyers. You need parental consent for minors in general, which is considered to be the consent of the minor. Whether that stands when they then become an adult and make a request it's a bit of a complicated question. And it'll be interesting. First of all, I mean, the right to erasure I was talking about, as I said, is not out yet, so unclear whether that would apply, but there still may be other laws even today that affect that request. It's an interesting question, and again, I think might require a little bit of specific advice. So I would encourage you to reach out if that's something that you're interested in knowing the answer to. So that's the end of the session for today. Thanks for those that stuck around. We do these every month, and if there's topics you want us to cover, do let us know. Otherwise, we'll be in touch over email. But thank you so much for attending. I hope you found it useful, and I will see you all again next time. Thanks, everyone.